Good morning. This is case LD 2011-0002 in the matter of Timothy A. O'Meara. Mr. Gordon?
May it please the court, I'm Joshua Gordon and represent the respondent, Timothy O'Meara. Attorney O'Meara didn't do anything wrong. If he did, it warrants at most a minor sanction. There are three separate charges. I hope to spend a minute. Pardon me, Your Honors, I believe he's the petitioner.
You might be right about that.
It's hard to tell sometimes who argues first.
But we like you both.
What should I do?
You can keep on going, or you can sit down.
Why don't you keep on
Choose.
going?
I prefer to go after him. Is that
All right. Mr. Cruz, would you join us then, please?
You're down 2 minutes.
Please, Court, good morning. I'm Jim Cruz, Assistant Disciplinary Counsel, representing the Professional Conduct Committee.
I'm Joshua Gordon. I represent Timothy O'Meara. If I could take a few minutes to explain my position. O'Meara didn't settle without authority. Now I think the story has changed to demand without authority. There was obviously no settlement until until March. But in December and January, Mr. O'Meara made demands, which he's required to make. I think he would suffer malpractice and perhaps ethical liability if he didn't. So there wasn't ever any unauthorized settlement, and the demand is within the authorization of his contract, if not his duty.
Does the record show whether his client actually reviewed the structure of a demand? I mean, those of us in civil practice, with experience in civil practice, would, I believe, always run the demand by the client first.
There's nothing in the record suggesting whether O'Meara did that or didn't do that. I think he regarded it as his duty and was within the contract to go and do that. If he didn't do that, he'd be remiss.
Provided he had his client's authority after explaining Dumas, the three Jolinuses or whatever, to his client. Did that occur?
I don't think there's any duty to explain a demand. There's certainly a duty to explain a settlement, but a demand is simply that first step in the settlement.
But you characterize it that way, Mr. But isn't really what you're saying is, everybody sort of understands that the first demand will be really, very high, so that nobody is likely to accept it. That's different than the prospect that it may actually be accepted. In other words, suppose you had a situation where a lawyer had a client, and the client said, I'm not going to be, I don't like lawsuits. I'm not going to be trying to claim that I've got, some pain and suffering that I really don't have, or that I'm emotionally upset. But all I want is my car repaired. And so that's all I want you to ask. And so in a case where, arguably the person would be entitled to, let's say, $25,000 in damage, the lawyer sends out a demand letter saying, I want, I'm hereby notifying you that I want this case settled for $5,000. And lo and behold, the insurance company says, wow, I don't know where this lawyer came from, but I'm accepting this deal. Could you then say, no, we didn't make this was just a demand, it wasn't an offer?
There's a big difference between your hypothetical and this case. This is a policy limits case. And the Dumas, in your hypothetical, Dumas doesn't really spring into action. Here, you are at or near the policy limits, and the insurance company has this duty to make an offer.
Had your client examined the assets of the insured?
He tried. He asked over and over and over, and they would not answer interrogatories saying we have insurance. So he really never had the ability to know with any sureness, other than with public documents, what the assets of the insured was. So
had he discussed the assets with his client?
I think they had many conversations about the assets, and it was O'Meara's belief that the assets were much greater than the insured amount.
But isn't,
Then why would you settle for the policy limits?
You might not settle, but you just have to make the demand for it. And I don't think you have to run that by the client. If the client said, don't make the demand, all I want is $11 million, and then a year later they sue you for malpractice for not making that demand when they realized they could have had $20 million. So I think I think that the lawyer has a duty to make that demand, and whether it's an ethical duty or not, I don't know. It's certainly malpractice exposure.
Your bottom line argument in your brief, as I understand it, is no harm, no foul. And your client does not admit that he did anything wrong. Am I right on that?
Well, I think my client does not admit that he did any wrong, but I think it's greater than no harm, no foul. I understand that you don't really know how much the settlement's going to be till the very end of the day, but Mr. O'Mara did a fine job preparing this case. He brought it to confession of liability. He brought it to a settlement at, what turned out to be the maximum amount.
At some point, the Conants agreed that he could be paid, I don't have the exact number, $750,000, something like that?
Yes.
And he was not willing to accept that.
Well, Your Honor,
That's a pretty good payment for the kind of work he did, no?
Well, it may be or may not be, but when a lawyer, when the settlement's $100,000, no one complains about a $33,000 lawyer fee. When damages are $1 million, no one really blinks at $330,000. But when damages are $10 million and the lawyer's getting $3.5 million, suddenly it's an issue. And I think that's what's going on here. Is that suddenly the lawyer looks greedy and overcompensated, and this family took out their understandable grief on Mr. O'Mara, who did a fine job for them. I want to talk about conflicts of interest. There's a conflict when the interest of the client is going this way and the interest of the lawyer is going that way. And of course, the two are never perfectly aligned. The client has an interest in winning their legal situation, and the lawyer has an interest in winning to make a living. Of all the allegations that I see, the only one that comes closest to stating any conflict is the Philadelphia courthouse meeting just before the mediation. And O'Mara did insist, he insisted that some agreement had to be reached on his fee before the mediation commenced. And admittedly, when facing a mediation that's going to change the course of Mr. Conant's life.
Let me ask you this, aside from this case, what if we have a situation where a case is about to go to trial and a lawyer tells his client, look, you've been tardy on making the payments as we have agreed to on a monthly basis of my fee. If you don't agree to pay me in total what you owe me right now, I'm bailing from trial.
Unethical.
What is the difference between that
case and
this case?
Excuse me, Your Honor. The difference here is that Mr. Conant, if they did not settle on a fee that day, that morning, they could not go through with the settlement negotiations that afternoon. That's because in structured settlements, you have to have the amount set aside for the lawyer as part of the settlement. You have to give the money people a number. And if you don't have that number, you can't go through with the settlement. You might as well just cancel the mediation session. O'Mara required that there was a number agreed on, some number, before the mediation commenced because you could not
They're about to go into
commence the
mediation, and I take it 4 or 5 days later, Mrs. Conant is going into some apparently life-threatening surgery.
Yeah.
So I ask, the lawyer knows his client is under terrible stress. Query, is there not a conflict in how the demand for the $2 million was made because of the lawyer's knowledge of the situation faced by his client?
Precisely the opposite, Your Honor. Because of his knowledge of the situation of the client, because she might die, mediation had to go forward then. If it was continued to the next mediation session, there was one a month later, she might be dead by then, and along with it goes damages.
Goes his fee.
And
because if she dies, then the family does not have to pay those millions of dollars in keeping her comfortable, alive, and whatnot. All of those medical expenses disappear. So query, doesn't your client have the greater interest? at that point.
I don't think so, Your Honor. He was fighting for the most recovery for his family, and that was what his understanding of the interests of the client was. And if he waited and she died, then the value of the case would plummet along with his fee. But nonetheless, the interest of his client was to see through mediation that day, because if they didn't, they might just lose their case entirely.
You said something a moment ago, Mr. Gordon, that confuses me slightly. I didn't understand from reading the materials that this mediation was to create a structured settlement. And if it was, I further didn't understand that in order to do that, the lawyer needs a number before he walks into the room. Can you elucidate a little bit?
Well, I think structured settlement was in the cards throughout this. I never saw anything in the record that anyone said anything other than this was going to be a structured
Well,
settlement. Sure,
but wasn't the mediation to affix a value to the loss, and then you figure out how to do the numbers later?
Yes, but no, you don't. All the money people were at the settlement at the mediation session.
Was a structured settlement reached?
It was structured settlement mediation, and all the people.
Was a structured settlement reached?
Yes. And in order to reach one, you have to have the amount of money that's set aside for the lawyer that comes off the top, and then you structure the rest.
How do we know that Mr. Conan understood that nuance? Because hearing it for the first time this morning, I'm not sure the average citizen would really know what that all meant.
Oh, I think this is way beyond the ken of the average citizen. I admit that. But I think Mr. O'Mara made repeated efforts to explain this to the Conants.
But you don't need to reach a hard and fast agreement. You can just tell the money people, assume X for an attorney's fee, and then we'll deal with the resolution later.
Well, I don't know whether that is possible, Your Honor. The way I understand structured settlements and the way I understand this record is that that number had to be reached. I think that's the way tort lawyers understand the structured settlement process.
Well, I understand differently. I understand that depending on the negotiations, the amount of the fee and how the fee is paid is actually part of the negotiation. So, I mean, I don't think, my experience is you don't have to go into a negotiation with a hard number for attorney's fees. It may turn out that the attorney says, look, I'll take X up front and forego future payments, and so the numbers attached to attorney's fees are equally as fluid in a negotiation.
Yes, they are. And certainly the lawyer can say, to make this work, I'll take something off my fee. But they had nothing. If all they had was a to be negotiated, and I'll contest that they did. I think Mr. O'Mara thought they had a understanding for $2 million on the way out the door on that snowy Saturday. But if they didn't, then it's really, I think it's very difficult to go into that structured settlement negotiation without some knowledge of what the fee is going to be, or else it's likely that the lawyer and the client are going to be bickering in front of the opponent and the judge, and that's not a strategic way to go into a settlement negotiation.
Can I ask you a question on a different subject? In the discussion between Mr. Davis and Mr. O'Mara, in which Mr. Davis accepted the offer, was there any evidence from either your client or Mr. Davis at the PCC hearing that your client said to Mr. Davis, you can't accept this. I sent you a letter 3 days ago saying that I withdrew?
What there was an agreement, and both Davis and O'Mara agreed to this. There was an agreement that any offers had to be in writing. And so O'Mara, whatever the conversations were, whatever they were talking about.
But let me go back to my question. Was there any evidence saying that your client said, what are you talking about, except I sent you a letter 3 days ago? No,
he misunderstood. I think he was flummoxed by the conversation and this reversal of what he understood as the way it's done, and how can you accept a demand, and that just didn't make any sense to him. And I think from looking at the letters that were never sent, which show up in his brief anyway, he went through a thought process. It's like, first he said, I just withdraw. Then he started thinking it through, and then he realized that Davis had sort of turned the whole thing upside down But there was an explicit agreement that it be in writing, and none of those agreements on the phone
So
really
I'm sorry,
count
I
for
guess
anything.
I'm sorry, what is your position then? Was that letter sent on the 20th?
26th I was talking about. There's letters on the 26th.
No, was that letter sent, the letter that is claimed to be backdated, do you say it was sent on the date that it has
No,
in
it was sent on the 24th, after
sent
their
on the
conversation.
24th.
That was a misdating, and I think it's just a misdating. But the reason that phone conversation does not create a contract is that though any offer had to be in writing, and it wasn't until O'Meara got a fax from Davis saying, I accept your offer, that is the first time that there was an offer in writing, and it was an offer for $11 million, which O'Meara promptly said no to. So there was never any unauthorized settlement. I want to say something personal. I try to turn square corners, and I would not have cited the arbitration testimony had I realized it was not in the record, and I apologize.
Thank you very much, Mr. Gordon. Case submitted. We will transition now to the